This is Michael Popok. It's After Dark. Do you know where your legal AF is? I don't know about all the president's men, but a lot of the president's men or former aides to Donald Trump have been entangled in criminal cases for a long, long time and civil cases. And now we've got, in the same week, worlds collide, right? Mark Meadows, disgraced former chief of staff. Jeffrey Clark, disgraced former acting attorney general. Michael Cohen, one-time consigliere, longtime consigliere and fixer for Donald Trump, all had results related to their various cases having been an aide to the president at one time or another. And we break it all down. I don't want to spoil the surprise. Something happened to Michael Cohen at the United States Supreme Court. Something happened to Jeffrey Clark at the 11th Circuit Court of Appeals. And something's going to happen to Mark Meadows at the United States Supreme Court. And we break it all down for you, the only place I know where to do it. Legal AF on the MeidasTouch Network. Take a listen.
So finally, Michael Popok, we talked about Trump's attempt to destroy the legal system, the games from within. Let's talk about the people in his world who are still trapped now within this legal system, who don't have the immunities of kings that the Supreme Court gave him. What's going on with these cases? You know, whether it's Meadows, Clark, Giuliani, pick your alphabet super fascist.
Right. We got all the president's men in various forms who are, as you said, entangled in the justice system. I'll do it in no particular order. We got Michael Cohen up there, and I did a 3-part interview with Michael that's up on Legal AF, the YouTube channel, at Legal AF MTN. One is up now, and the rest will go up over the weekend, right on the heels of the United States Supreme Court in a one-line order denying his appeal. Michael had what I thought was a very compelling case, and one that's important to America and to not just to Michael Cohen. He would have been the named plaintiff, obviously, or is the named plaintiff. But what he very I think acutely recognizes is that he was the first political prisoner ever jailed in America for exercising his First Amendment rights against the sitting president. He was let out. He was convicted. He pled guilty. He's paid his debt to society, more than paid his debt to society. We know that, and was sentenced to 3 years in prison. He was let out because of COVID to do home confinement in lieu of being in jail. He has a series of health conditions that could have made COVID deadly for him, and he was put out. And then he was doing his thing, which you're allowed to do when you're out, including First Amendment right, expression, criticizing the king, criticizing Donald Trump. Had a book coming out about that, and he went down to a meeting with the Bureau of Prisons and others that he thought was just going to be a simple check-in and to sign a document to allow him to continue to stay out on home confinement. And instead they put effectively a gag order in front of him and said, yeah, you can stay out on home confinement, but you got to sign on the dotted line that you're not going to continue to criticize in podcasts and social media and books Donald Trump. Sign on the dotted line or we're going to send you back to jail. And he did not sign on the dotted line, and they immediately remanded him. There was like a federal marshal outside the room. They immediately remanded him back to federal prison and threw him not only in the clink, threw him in solitary confinement for 16 days. So bad that senior judge Alvin Hellerstein, who's done things against Donald Trump recently, said that it was a obvious retaliatory move by the department, the Bureau of Prisons, on behalf of Donald Trump, and had him immediately released from confinement and from jail and sent back to home confinement. And then Michael tried to sue under a series of constitutional claims Donald Trump and the government for having done that. And it was denied at the appellate level in New York because the certain type of action that Michael brought, we call it a Bivens action. I'm not sure that was the right one to bring, but they brought a Bivens action. And the Second Circuit said, yeah, under the current Supreme Court rulings about Bivens, you could almost never sue a federal officer. They always have, we're back to immunity here, immunity from civil liability for doing their job or a version of their job, even if it was retaliatory. And so he lost at the New York court of a Second Circuit level. Then he lost at the Supreme Court level, which is terrible because Michael is a poster boy for what could happen to all of us in a next Trump administration, not to keep beating this dead horse here on this episode. But if Donald Trump turns the turrets of the military and uses the justice system to go after his political enemies, which he's already named. They are Democratic elected officials. They are voters. They are election officials. They are elected officials. They are podcasters. They are media. I told everybody, don't worry. Ben and I will be rolling around in an old van with a low wattage transmitter if we have to, if we're taken off the air. I only say that half in jest. So Michael is that poster child. So Michael lost. Then we've got Mark Meadows and Jeff Clark, who are sort of inextricably tied together, not only because they were both co-conspirators and charged in Georgia for participating in a coup against America, but because they've both been trying to get things to happen in federal court, and so far they have been unsuccessful. Mark Meadows just got denied by a Trump-appointed judge, Judge Kelly, in federal court in the district of in DC, in his attempt to try to, this is ironic, to try to get documents in the National Archive, which he says could help him defend his criminal case in Georgia. Isn't that ironic that he worked for the guy that didn't turn over things to the National Archive, but yet Meadows wants the things in the National Archive in order to defend himself? You see why we need the National Archive and proper record keeping and presidents turning things over, Mark? So the judge, on a jurisdictional technicality, said, yeah, this is wrong court. No, denied. And you can try to do it another way, but you're not going to do it this way. So that was denied. Meadows got rejected 6 months ago by the 11th Circuit Court of Appeals, which is currently the same court handling the new Trump Mar-a-Lago appeal issue. He got rejected from trying to drag his state court case over to federal court, which Jeff Clark, the disgraced former acting attorney general, insurrectionist, he tried to drag his case over with some fake electors from Georgia as well. And the judge that was assigned, Judge Jones, rejected both efforts on that. The 11th Circuit 6 months ago came up with a unique reason. They said, we recognize that current federal officers who are being prosecuted in state court for something that they did within the color of their office, and maybe they have a federal defense, get to go to federal court to have their case tried, and then federal defense is up to the U.S. Supreme Court or be adjudicated. But you're the former White House chief of staff. It's right there on your business card. And you're the former Jeff Clark, the former acting attorney general. You're not current. And so they rejected the attempts to remove in the appeal on that grounds. Mark Meadows didn't like that response and has something up with the United States Supreme Court for them to determine whether Chief Judge Pryor of the 11th Circuit was right or wrong about whether the federal removal statute applies to former officers or not. And a little bit of an esoteric thing. And, the Supreme Court has not been shy about sticking their big fat thumbs on the scales of justice in favor of Donald Trump. And so I anticipate that they're going to determine whether the 11th Circuit was right or wrong about the application of the removal statute. And so the answer to the question that comes up in the chat a lot, why are they trying to go to federal court? It doesn't get rid of their indictment. It doesn't. But it gives them a federal judge and some federal arguments that they think they'll get a friendlier face about, a friendlier forum about, to make arguments about. Now back to the top of this episode, separation of powers. And I worked for the president, and this is the department of, and I only did things for him, and you can't prosecute me related to them. And all of those, the immunity, Jeff Clark's like, well, he got immunity and for talking to me. So why don't I get immunity for participating in the coup? And so this this is the thing that I want people to be prepared for mentally. This is one of the reasons that you and I put together the idea for Legal AF, the channel, the YouTube channel, is because this Supreme Court is going to be actively involved in for the rest of 2025 in things that matter, including cases that will be before them before I think this election gets certified as to its result. I think they're going to be handling cases on an emergency basis at the Supreme Court level about voting, about certification, and then about things related to Donald Trump and his new attempt not to recognize the will of the people should he lose, is all going to be all handled by this United States Supreme Court while they continue to issue new rulings about the executive branch, the three co-equal branches, and their perverse, warped view of the separation of powers.
We'll look at what the Fifth Circuit far right-wing Fifth Circuit did. They made a ruling in a case where they didn't even have to necessarily make this ruling even right now, and it was done intentionally, which basically to say, if the votes don't arrive on election day themselves, so if absentee votes or other votes are postmarked before but happen to, arrive afterwards, or what if there is some, ministerial mistake made in a specific office, or, it just so happens that another batch of votes that are intended to show up just show up late because remember when Donald Trump's plan was to gut all of the mail services, and he still is. I mean, they still have that, the postmaster is a Trump lackey who from within is like causing actual harm to, the efficiency of the post office itself. It's like an anti-post office postmaster, the same way Donald Trump had anti-labor people who would be on the national labor relations boards and things like that. Under Supreme Court doctrine that we've talked about for years called the Purcell principle, this is basically federal court abstentions, what it's supposed to be. Federal court abstention for making decisions like the Fifth Circuit made before an election. Now, what the Fifth Circuit said to kind of recognize the Purcell principle, but giving Donald Trump kind of a quiver in his arsenal, if you will, was they said, we just think that in general, it is unlawful for votes to be counted if they arrive after election day, regardless of what the circumstances are. Even if it's, the post office screwed it up or there's a mistake that was made, not by the sender, but by who knows in the chain of command where that got. They go, we're not going to opine on that. But Michael Popok, as you know, what the Fifth Circuit was really doing there was just giving an argument, putting it on the table so that it could be made as an argument to the Supreme Court if we're talking about a situation that probably looks more analogous to a Florida circa 2000 than, that, well, look, we've preserved this issue, even though people are like, well, the district court probably will make the ruling that this doesn't apply to this election. That's not what the Fifth Circuit was doing. The Fifth Circuit was basically inviting Donald Trump, hey, in the event this election comes down to a few hundred votes in a state like a Nevada or a Georgia, make the argument that all of those votes are avoided if they come in after. Use our Fifth Circuit for a nationwide injunction, go to the Supreme Court. So that's really what that ruling was about. Now, if the election is, the thing about the 2020 election, about all of this, was not a close election. Biden destroyed Donald Trump. It was not close. Sure, you can say in certain swing states it was close, but even the states where it was close, like a Georgia, for example.
It's 11,000.
Still 11,000 votes in election law is not like hundreds of votes where
he won
you're
by 8
analyzing
million votes.
chads and things like that. So
he won by
that's
8
what they're
million
doing
votes.
there, Popok, to your point about the Supreme Court.
Well, and let me just make it even more nefarious. They chose Mississippi, which is where the case came up to the Fifth Circuit, because they were forum shopping, the Federalists, the right wing, the MAGA. Where can we go to bring a case now that will pay dividends later? Where's the soft underbelly? It's either Texas or Mississippi, something, Louisiana. It's something in the Fifth Circuit, because the Fifth Circuit is dominated not just by right-wing leaning appellate court judges, but by Trump-appointed right-wing leaning appellate judges. Two in particular, Judge Oldham and Judge Ho, H.O., are both trying out right now. Speaking of job offers, they're both trying out for a Supreme Court position for Donald Trump. And they were on this panel at the Fifth Circuit, came up from Mississippi, which does not have a mail-in ballot problem. But 20 other states in our country have, including ones that I have voted in, including Florida back in the past, they have a grace period of 5 days for mail-in votes coming in from anywhere because of the mail, as long as it's postmarked, sort of like mailing your tax return. As long as it's postmarked the day that it's due, you got an extra 5 days. Oh, not according to Judge Ho and Judge Oldham and the guy that wrote the opinion. No. That changes federal law. Federal law says election day. It's got to be arriving on election day. So Mississippi didn't have this problem, but Florida has the grace period. New York does. California does. and a lot of other battleground states, like you said, like Nevada. So they were like, let's just get this going through the Fifth Circuit, because then we can take it, as you said, to make the argument about all the mail-in ballot grace period states. If this comes down to we're searching for votes in the couch pillows again. Can I just say, just to be hopeful for a minute, this is the Popokium segment of the podcast. I think there's two likely scenarios for this election. It's either what the media has been force feeding us, which is going to be razor thin, like two sports commentators that want to make a blowout that's going on the screen look like it's competitive for ad dollars. I think that's going on. I think, sure, it could be razor thin, but I think it's more likely that this is going to be a quote unquote blowout for Kamala Harris, with so much pent up demand to vote for her and to vote against him, just waiting for an opportunity, i.e. the ballot. Because every time they've had an opportunity to actually vote in some way, it's gone tremendously in the favor of the Democrats. Every special election that matters in the last 2 years, the midterm election, can be interpreted as a major win for the Democrats. And that was with Joe Biden still at the top of the ticket. Every special election where abortion or women's rights or seats, either controlling a Supreme Court or a special or a district in Congress, all Democrat. Look at the money, the dam broke for money, because that's the only way you can vote before you vote. You vote with your pocketbook, your purse, and your phone. All overwhelmingly Democrat. Now we just got to put it into action and vote. And then I think this is either going to be maybe razor. I don't think it's razor. And all these made up stories that corporate media is speaking about corporate media. Oh, black men are not going to vote. Oh, this or that or not. That is all bullshit. Okay. If the vote totals come in the way, it's going to be overwhelmingly 300 plus for Kamala Harris. Is there a scenario where Donald Trump can win? Yes. That's why you and I are working 23 out of 24 hours a day to make sure it doesn't happen. Welcome back. That was Legal AF, the podcast, Wednesdays and Saturdays at 8 p.m. Eastern time, and wherever you can pick up your audio podcasts from. If you're already part of our audience, you watch us, you listen to us on podcast platforms. Let's see, we're top 50 in news in the world. We're top 10 in news analysis in the world, and it's all because of you. We sit at that intersection of law and politics so that you don't have to. We bring you that show twice a week, just like that, and then hot takes like this. And if you're geeking out on that, you're going to love this announcement. We have a new YouTube channel, Legal AF, the YouTube channel, at Legal AF MTN is our handle. I'm the chief curator. I'm sitting at the intersection of law and politics, and I'm bringing you a lot of my stuff. I mean, 5 or 6 hot takes a day there, deep dives, deeper cuts than I could even do on the MeidasTouch network or even the podcast, and then exclusive content that we're getting from other Midas Universe contributors and new contributors. We've got new shows like Unprecedented. Once a week, I do it with Dina Dahl to talk about the United States Supreme Court. What else? We've got Court Accountability Action, one of the leading investigative bodies and entities that are focused on corruption at the federal court system up to the United States Supreme Court. We got everybody over there. Come join us, Legal AF, the YouTube channel at Legal AF at MTN. Let's try it again. At Legal AF MTN. This is Michael Popok, and I'm reporting. In collaboration with the MeidasTouch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.